Okay, this is CPL 180.85. I'm going to start out with a background of what was the catalyst for this section per teacher's impartation. Is that a word? For what the teacher imparted. Hold on, I gotta cross the street. Okay. So what's going on here is the judge, and by the way, the title of this is Termination of Prosecution. So this first part is going to be the background so that you understand why this was put in. So judge finds reasonable grounds that felony has been committed. Okay, judge is going to hold the defendant for grand jury. So the papers are sent up to the superior court. So you know what happens when the superior court gets the papers, then the jurisdiction is terminated in LCC, right? We know that. All right. And so, but they still have to convert the felony complaint. It still has to go through the grand jury to turn into an indictment, right? So they're basically holding the defendant, or the defendant isn't incarcerated, but in essence, they're holding him for grand jury action. So this person is in limbo. This case is in limbo, right? Da-da-da-da. Now what ends up happening is this case is just going to be sitting there. A month passes, 2 months pass, okay? So that's not good. So this is where 180.85 comes around. Because the whole thing is like you're thinking, okay, what about speedy trial? But again, those papers have been transferred to Superior Court. So nobody can file anything in lower criminal court. They can't make a motion. And there hasn't been an indictment yet. So Superior Court can't do anything with it either. So this is what has put 185.85, the order of termination of prosecution in. All right, so if felony complaint is sitting around, here are the time frames. For 12 months or more, 12 months or more, it's sitting there for a year or more, 12 months or more. Those are the specifics. Okay, to terminate this prosecution, the court, anyone can do it. The court, the DA, the defendant can do it. Okay. If it's done, the court has notified the parties within 30 days for a return date. Okay. On the return date, if DA doesn't oppose, then the case is dismissed. So, return date, 30 days. DA has not opposed it, case is dismissed. Now, if the DA files notice of opposition, okay, he has 45 days to indict, to put, get the indictment, right? Now, if the DA, there's no indictment in 45 days, they can make an application saying, we have a reason for not indicting him, asking for good cause to have dismiss, okay? The judge will dismiss. Okay, now within that 45-day thing under number 4, I saw another time frame, so I just noted that. So the prosecution the DA gives defendant 5 days written notice that they're opposing, okay? And otherwise, if they indict him, the whole thing gets dismissed. I don't know why the instructor said it like that, but basically, if there's no indictment, it gets dismissed. The DA can still, after this order, right, to terminate prosecution, even after that, the DA can still try to get the person indicted. So that's in section 7 if you want to read that. Now, also in Section 7, another thing I wanted to note was that there's a stay of sealing, 160.50, for a reasonable period not to exceed 30 days to permit the people in opposition to pursue indictment. So just know about that. Stay of sealing for a reasonable period not to exceed 30 days. They're going to seal the records. And one of the things that the instructor had mentioned was that it was not good if that person's going up for a license or employment for the felony complaint to be sitting on his record during that time where the case is just sitting still. So that's probably, this is part of it as well, that there's a stay of the sealing so that this person is able to go out, get employment, do what they need to do while the case is still kind of like in limbo, okay? And that is 180.85, termination of prosecution. Thank you.